United States Commission there has been a recent development. The Securities and Exchange Commission filed a lawsuit against XRP sales in December 2020. Judge Anoris has granted permission for both parties to submit a motion to seal private papers that they jointly provided on March 20,224. Before we move any further, please kindly support our channel by pressing the subscribe and notification bell. This request was agreed upon and granted considering the many approaches to settlement in the court's ruling, which contains material that pertains to the many options that have been presented for the settlement of the matter. Ripple and the SEC have defended the choice to partially conceal these data to protect sensitive information involving financial activities, a changing timetable, and redaction. These details may include Ripple's financial statements and specifics surrounding the litigation. The Securities and Exchange Commission will face a setback in the Ethereum case as a result of the statement distributed through X, which emphasizes the impending public exposure of these materials, which is scheduled to take place in PL. The CC has filed its opening remedies-related brief and supporting documents under seal. These materials are not currently available to the public via the Ripple R framework. CC announced that censored public versions must be submitted by Tuesday, March 26, 2024, at the latest. This date is important because it emphasizes how important the case is. What you can expect from Ripple and the CC gaining a comprehensive comprehension of the nature of the significance of a beginning fixes pertinent synopsis the opening remedies-related brief, which is essentially the first submission made by a party, in this case, the CCC, explaining the specific legal and financial remedies it seeks from the court against the opposing party, Ripple Labs, is the cornerstone upon which the lawsuit procedure is based. It will be interesting to see OB serve the amount of money that the SEC asks for in the sales of XRP by institutions after the start of the legal battle. The number of remedies that the Securities and Exchange Commission, or CC, is demanding is much awaited. Lisa and the U.S. District Judge have ordered Ripple. The Securities and Exchange Commission claims that Taurus must provide its financial accounts for 2022 and 2023, as well as contracts on institutional salseros of XRP in February to establish a reasonable remedy. Despite Ripple's argument that information about its financial health is not only not relevant to the case but also highly confidential, the court has determined that such material may be potentially significant to the remedy stage of the proceedings. The Securities and Exchange Commission (SEC) argued in its motion that having access to the company's financial data is essential to pursue legal action. Additionally, Bitcoin has reported on this development. The processes for sealing and redacting court documents that are relevant to the remedies phase of the action are outlined in this agenda. This is an essential component of the proceedings that will decide the legal and financial implications for Ripple Labs in the ongoing legal struggle between Ripple Labs and the Securities and Exchange Commission (SEC). The Southern District Court of New York was presented with a comprehensive timeline for the remedies phase by Ripple Labs and the Securities and Exchange Commission (SEC) just a few days ago.